We are right on time, which we covered a lot today. And so I'm happy to say that. So we are going to switch gears now and talk a little bit about the questions that have been submitted today. So I'm really happy to see that we have over 100, at one point we had 130 different people joining us on Facebook Live and on Zoom collectively. It looks like right now we have about 18 questions. So if you have any questions, make sure that you're submitting them either on Zoom or on Facebook Live in the comment box. So we're going to start with the first question. What is the HOA responsibility for a tree on a private lot that is encroaching on 3 other homeowners' property? Okay, so lots of issues here. So it appears that the tree is on a private lot. I'm assuming that means it's a homeowner's lot. And I'm guessing that this is like a 4 corners type situation, right? Where the tree's on one lot and then maybe is growing, the branches are growing, extending into the other properties, lots. Well, if the association, it's not the association's tree apparently, and, it sounds like this is a homeowner to homeowner issue. So I guess then I flip over to what can the homeowners do if you have a tree that's encroaching on your property and it's not your tree. So what Arizona law says is that you can trim the tree back to the property line. That's something you can do. I think probably a first thing you want to do would be to reach out to the homeowner who has the tree on their property and ask them first to trim it back. And if they refuse, then you certainly have the right to trim it back to your property line. But I don't feel that the association has any responsibility here. I mean, obviously, if you notify the association, it's possible that they may be able to write a letter to the owner that has the tree. It's not required. Just saying that we've received complaints regarding your tree and, please contact your neighbors to discuss this. It's something, of course, you can do. If you don't know the owner's name, you don't want to knock on their door, you can look up their property address on the Maricopa County Assessor's Office, and it'll give you their name and their contact information. Okay, next question. Developing an HOA manual, policies, procedures, board code of conduct, roles and responsibilities, budget, reserves, board meetings, bylaws, maintenance grid. What do you think? I think that's awesome. And the great thing about this is you can pass it on to future generations of board members, right? To board members typically, don't stay on the board for 20 years. So somebody serves 2 terms and they leave, it's longevity. You can just pass this information on to make the job easier for future board members. So I love the idea. It will take a lot of work. But I think all these points you've made here are an excellent idea and is something I would advocate you doing. Question number 3, how can our HOA enforce our CC&Rs if we don't have a fine schedule? So great question. You're not required under Arizona law to have a fine schedule. There was a case, several years back that talked about the importance of having a fine schedule, but that case was ultimately depublished. So it's not relevant for our HOA condo industry. Here's what I can recommend to you. So if you want to enforce your CC&Rs, there's lots of different ways that your board can enforce it. First, check what your CC&Rs say about enforcement. Typically, you can file a lawsuit against the owner for whatever they're doing or not doing. Go to Superior Court, get an injunction. That's a pretty aggressive thing to do. Before doing that, you may want to send a courtesy reminder letter, a demand letter. You may want to turn the file over to your attorney and have them call the owner and reach out to the owner regarding the violation, or have the attorney write a letter. Another thing that you can do is levy fines. Under Arizona law, you're not required to have a fine schedule, but you are required to follow the fine process. And that means that you have to give notice of the violation. The violation has to be, a violation of the CC&Rs, bylaws, or rules of the association. After giving notice of the violation to the owner, you have to give them an opportunity to be heard. And that could be an opportunity for them to send an email back or come to a board meeting and explain their side on the violation. And then after the opportunity to be heard, then you can levy the fine. And so fines are an effective tool that you can use to get compliance. Remember, once you levy the fines, the only way that you can collect them is by going to justice court or superior court if it's over $10,000 in fines, and getting the justice court or superior court to give you a judgment, a piece of paper saying Johnny Appleseed owes ABC Association X amount of dollars in fines. And then you can record that judgment and it becomes a judgment lien. Another thing that you can do to enforce your CC&Rs would be to go to the Arizona Department of Real Estate. They have a special arm of the ADRE that hears disputes between owners and associations regarding your association's documents and regarding Arizona law regarding HOAs and condos. Now, the ADRE can just issue, an opinion saying that somebody is or is not violating, the documents or state law. It doesn't have any injunctive relief where they can force somebody to do something, but it's a ruling by an administrative law judge. So there are lots of things you can enforce your CC&Rs by doing, right? So again, you can send courtesy reminder letters, you can send formal violation letters, you can have your attorney call the owner, have your attorney write a letter to the owner. You can fine the owner as long as you're following the process under Arizona law. You can go to Superior Court, get an injunction, which is an order compelling the owner to comply with your CC&Rs. And you can go to the Arizona Department of Real Estate and have an administrative law judge, make a ruling as to whether or not somebody's violating the documents. Okay, question number 4. What are all the assessments a condo association can levy against the owners? For example, regular assessments, special assessment. Are there any other special assessments that do not have any dollar limits? So this is a great question. You really do need to look at your association's documents for your condominium, and that will levy the different charges that you can charge your owners. So the typical charges that we'll see in, a condominium association's CC&Rs are going to be, the regular assessment. And how much you can raise the regular assessment will need to be listed in the condo documents. Now, I know you put in your note 20% above the prior year assessment. You might be referring to a law that pertains to planned communities. If you're a condo, that state law about it can't be more than 20% of the prior year's assessment, or a smaller amount if your documents call for a smaller amount, that applies to planned communities. For condos, there is no limit on how much the regular assessment can be increased unless there's a limit in your documents. So start by looking at your documents. So you can charge regular assessments. Most condominiums also can charge or levy a special assessment after getting a vote of the membership. You may have some provisions in your documents that say that if an owner damages something, that you can, repair, the damage and charge the owner for it if they did that. Or you may have self-help in your documents, and that says that, if an owner isn't maintaining something on their property after giving notice, you can go in and repair it and then charge the owner for that. Some other things that you can charge under Arizona law, maybe if your association has in your CC&Rs you might be able to do like a transfer fee when the property is being transferred, or a capital improvement assessment. But again, all of these have to be in your CC&Rs. Under Arizona law, you can charge new buyers a disclosure fee for disclosing information about the association. So those are kind of like the normal fees that we see. You have to be careful on the fees that you charge for a rental of a property. We are limited for charging owners for renting their property. There's a $25 fee that we can charge, and we have to provide them, with notice that they have to pay the fee. And then we ask them very few categories of information regarding the rental that we're allowed to ask under Arizona law. So that's another small fee that you can charge. Also late fees if they don't pay their assessments on time. But really, go back and look at your documents, because your specific documents for your association will outline in your CC&Rs what things you can charge for, what assessments can be levied. Okay, question 5. In regards to the new law on street parking, does this also include vans and motorhomes? Very good question. I don't think I'm going to go back up and look at the language. That's why I love teaching these classes, because you really have to look at the laws, right? So it does appear that it would. because it says that the association, would not be able to regulate any roadway if the street has been dedicated through governmental agency. But that being said, you're going to want to check with your city, town, or municipality to see what their rules are on motorhomes and, commercial vehicles, that type of thing too, because, if the streets are dedicated to the government entity may have their own ordinances that pertain to that. Okay, next question, number 6. Memorial Day is approaching, and there is a banner of flags across the top of a couple of the townhome garages, along with a long, narrow flag near the entryways with a couple other small decorations. We looked through our governing documents, our CC&Rs, bylaws, and rules. The only thing it states is that you cannot alter by changing the integrity of the structure by modification, defect, and improvements, and you need an architectural request for flags. What are excessive items or decorations? It's a tough question because it's kind of, it all depends on, I have to see a picture usually. It's kind of like, what the Supreme Court says. I know it when I see it. But I think a couple things to think about. Number 1, you should really go look at the approved flag list under Arizona law that owners can have on their property. So they can have an American flag, an Arizona state flag, Indian Nations flag. There's a whole list of the different flags. And last year it was updated to include first responder flags and, a number of other flags that are allowed. So I'm assuming, you didn't say specifically, but Memorial Day is approaching. So I'm assuming that this is kind of like a red, white, and blue themed type display. And the banner flags are probably maybe the United States flags, or, because it sounds like it's a long, narrow strip. Maybe it's just red, white, and blue, or stars and stripes or something. I guess a couple things. Number 1, something that I would be thinking about. Do you want to be on the news as a board? Would be number 1. So if you tell this owner, in the month of May, when we are celebrating Memorial Day to honor our, fallen veterans, if you tell them, hey, you can't have this patriotic display, or if you do it on Veterans Day, or you're doing it on the 4th of July, I think you're going to be on the news because it might be perceived as being an unreasonable, prohibition, or, this is the bad HOA, being nitpicky. And so, be really careful of that. One thing that you could do is, if this is the type of thing that this is up all year, maybe what you do is, adopt a policy for your association that talks about seasonal decorations, and, maybe say seasonal decorations can go up 15 days before the holiday, and then they need to be removed 15 days after the holiday. But remember, if it's an American flag or any of the other protected flags, those are allowed to be up at all times. So hopefully I've given you some suggestions. Be reasonable, because I don't want you on, the news for being that big bad HOA that's making somebody take down their decorations. Okay, next question is, can an HOA use the money in the reserves to remodel and improve some of the common areas? That's a pretty general question, but what I would say, kind of a rule of thumb, would be any money that you have in the reserves, you should be spending it on, long-term capital improvement projects that are outlined in your reserve study. If you don't have a reserve study done and you just have like a savings account for your association, and you want to use the money for that, I need to know more about what is remodeling and improving. What does that mean? And are there any other legal issues that may come up with remodeling and improving your common areas? Because sometimes your documents say that if you're changing the use of a common area, that you need to get a vote of the membership before you do that. So you'll want to, reach out to our firm or your legal counsel to ask for more specific information on this, like what specifically do you want to remodel in the common areas, and how much is it going to cost, and is this in your reserve or not in your reserve study? And is there anything in your CC&Rs that might prohibit you from doing this without a vote of the membership? Okay, next question, number 8. Our treasurer routinely sends a large volume of emails to our manager, typically 30 to 40 per month, often multiple emails in a single day. The treasurer continues to do this in spite of our requests that he limit the number of emails. The manager has indicated to me and to him that if this continues, she's going to ask to be reassigned from our account. What suggestion would you make regarding the well-intentioned but excessive communication by the director? Okay, this is like a very common problem. And even when I was the president of my association, I had another board member that was actually doing this to me. And it was like 300 to 400 emails in a 3 or 4 month period. And it was honestly driving me crazy. So I get it. This manager, and if you really like this manager, you're going to get manager burnout if you don't address this quickly. So I think it's unreasonable, just from my perspective as a board member, to be bombarding your manager with 30 to 40 emails a month. It's too much. And so I think your board needs to talk about a protocol for who can talk with the manager by email and what types of things are urgent and what types of things should wait till the meeting. And so what you may want to do is you may want to get a better idea as the president. Okay, like, what are these emails about? And so maybe ask the manager to share over the past 2 weeks. Can you share with me, just forward me the emails that the treasurer has been sending to you so I can get a better feel for what's going on. I don't know, are these like mean emails? Are these just, I have so much time on my hands that I'm bored. I want to reach out, the manager and talk. I don't know. Is the manager screwing up? Like, is the treasurer raising valid points? I don't know the nature of the emails. So I think you need to get to the bottom of that first. And then I think you need, as a president, I think you need to talk with the treasurer and, after you've looked at the emails and come up with a plan for how we can better handle the information flow. And so maybe one suggestion is that only the president can email the manager outside of a meeting. Maybe that's one option. Another option would be maybe the treasurer only sends one email a week to the manager and lists everything in one email, and then copies the president. So the president is kind of in the loop on what's going on. I think good communication with the treasurer and the manager on this can help you better frame the issue and then come up with a plan so you don't lose the good manager. Okay, question number 9. Assume that an HOA board of directors 2023 budget reflects a net loss equal to double the association's annual revenue, risking possible insolvency. Further assume that some actual 2023 year-to-date line item expenditures are discretionary and materially exceed the budget. What are a board's limitations, if any, in approving such a budget and subsequently dispersing association funds in excess of the budgeted line item? Okay, your association needs help because just based upon what you're telling me, the red flags are going up left and right in my mind. Okay, so a budget being proposed to your board that has, expenses that are exceeding your revenue, by 2x, that's not a balanced budget. And you're right, it is a pathway to insolvency, or, not having enough money to pay the necessary bills for your community. So you need to go back and look at the budget, go back to our cheat sheet and on budgets, and you need to revise that budget right away. And that may mean that you have to increase your revenue. How do you do that? You may have to look at how do we increase our assessments or how do we levy a special assessment. You probably need to get your attorney involved in this, or our law firm can help you, but you have serious problems and you need to immediately, we're already in May, you need to immediately revise that budget and balance the budget. So that your expenses meet your income. The second thing I would say is, okay, when you're in the situation already where you're operating at a loss, 2x loss, now you're spending things on discretionary items. Now, again, I'm seeing this question framed by somebody. Whenever I teach these classes, sometimes I'll get an email the next day from a board member saying, that person got it all wrong. They didn't tell you all the facts. I don't know. it's hard to define a discretionary expenditure because, is fixing the pool pump a discretionary expenditure? I don't know. For me, I would think it's a necessary expenditure, but some people may say we could chain the pool shut, right? So, I'd have to better understand, what the discretionary budget items are. If they're not in your budget, sometimes there are surprises that come up that aren't in your budget for that year and you have to adjust. That does happen. I had an email this morning on my board where, we're going to be talking about it at the board meeting in 2 weeks that, hey, this issue's come up and it's not in our budget. Wasn't on our radar, but it needs to be on our radar now and we need to deal with it. So we're probably going to have to cut expenses somewhere else to meet that budget item. Okay, question 10. How can a board meet to work on a strategic plan if all board meetings are to be pre-announced and comply with the open meeting statutes? The best way to do that is to just make it an open board meeting, but call it a strategic plan board meeting. So the board's just discussing things. Homeowners would be allowed to listen if they want to. If you don't want homeowners there, then have less than a quorum meeting to discuss association business. Less than a quorum doesn't have to comply with the open meeting law. Invite your attorney to come to the meeting and you could be getting legal advice from your attorney and it can be an executive session. That would be a workaround on the open meeting too. Okay, question number 11. It looks like we are up to 23 questions. Is there a dollar amount, capital expense, that has to be voted on by the members? Check your documents. Some documents say that if the board is going to spend over $100,000, it needs to be approved by the membership. And by check the documents, I mean check the CC&Rs, the bylaws, and the articles. Sometimes there's a weird provision in the articles of incorporation. Okay, question 12. Our association is responsible for all of the street maintenance. Also, street signs say private, which means patching and repaving. We are an older association. How do we fit in the new law? If you're responsible for maintaining your streets, that new law probably does not apply to you. So again, the criteria for the law to apply to you is that you have to be a planned community, number one, which you check that box, it sounds like, and the streets have to be dedicated to a governmental agency. And so if you're maintaining it, I'm confident that the streets are dedicated to a governmental agency. So the new law does not apply to you. Okay, next question, number 13. What do we do with reserve funds if a reserve study says we do not need a reserve fund? We have no amenities, no gates, no monuments. We only have 5 HOA-owned lots, which are maintained through operating funds. So I guess one thing, if I were looking at this issue, that I would wonder is, okay, are these like vacant lots? Sounds maybe like it is. I would think that the maintenance on that, do you plan to build on these lots or do you plan to sell them at some point? You're right. If it's just general maintenance, like let's say they're just tumbleweeds blowing around, you probably don't need a reserve fund, but I would need to know a little bit more information about, the lots, to answer that question. Okay. Question number 14. Can you create a rule and regulation that contradicts the CC&Rs, such as planting in front of your home that is considered a common area? No, you should not be creating a rule that contradicts the CC&Rs. You can't do that. Now, that being said, sometimes associations, I don't know what the specific language is in your CC&Rs. Maybe it says that just this front yard area is common area and the association is responsible for maintaining it. Maybe it says something more specific, like the front area in front of your lot is common area and owners are not allowed to plant in it. And so you can't create a rule to do this. There are certain circumstances where if we look at the language of the documents, maybe the association can allow, the owner to plant something if it's not specifically prohibited in the common areas. It's sticky to do it because then the question comes up, well, okay, somebody wants to put a tree in the common areas. Who's going to maintain it? Who's going to maintain it after this owner no longer owns the unit? And so all these issues really need to be thought out, and possibly there needs to be, something recorded that talks about, maintenance of these items. Is there going to be irrigation? Who's going to pay for the, water for the irrigation, et cetera? But it's typically not normal that the association, allows somebody to go, an owner to go and plant a bunch of stuff in the common areas. It's rare, and it needs to be documented in a certain way. Okay, question 15. Our documents require 66% yes votes to change the CC&Rs. Election of board members requires a 10% quorum for the meeting. For the parking vote, which do we need? Okay, so you're not changing the CC&Rs. You're basically just voting on whether or not, to continue to, to be allowed to regulate the roadway. I mean, it's a really interesting question that you're raising here, though, because the way that the statute is written is that it doesn't say you have to amend your CC&Rs. It just says that you have to call a meeting of the membership and vote on whether to continue to regulate the public roadways or not. It's not saying that you have to have an amendment to the CC&Rs. Of course, you could structure your vote that way. So I guess it's interesting to see that. So you're going to have a quorum, which is going to be 10%. And then a majority of that number of votes. So you need to have a quorum of the membership and a majority of that number of votes to continue regulating public roadways. So this is a good clarification question. So let's make this easy. Let's say that you have 100 owners in your association, in your planned community, and your quorum is 10%. So you would need 10 owners to show up at the meeting, have a quorum to vote on this. And let's say that actually you had more than a quorum. Let's say that 30 show up. You're going to need to have, a majority of that number of votes, so a majority of 30. So you need to have 16 vote to continue regulating the roadway. My worry here is that it's a majority of a quorum, even though the law didn't specifically say it that way. That's the way that I read it when they say you have to have a quorum of the membership and a majority of that number of votes. So majority of the quorum to pass this. I mean, with my little example, it seems like, oh, hey, it's no problem to get 16 owners, right? But the reality is for some of these larger associations that have 1,000 owners, if you have a 10% quorum, 100 owners, that's a lot of people to get to come to a meeting on a parking issue. And let's be real here, most people want to park their car in front of their house, and so they're going to be all in favor of getting rid of, regulation of roadways in an association where the streets are, dedicated to the public. So I think it's going to be a hard vote to get. Okay, so short answer would be you don't need to change your CC&Rs. That's not what the document, what the new law says. It just says you have to vote on the issues. So you need majority of the quorum for your association. I mean, it is kind of complicated because if it passes, and you're no longer regulating the roadways, at some point you're going to need to do an amendment to your CC&Rs and change that. I'm not saying you're required to do it, immediately, but it's an inconsistency, and you're going to want to make sure the meeting minutes have a really good paper trail on this, so that future boards will understand exactly what happened and why we're not regulating the roads if it goes down that way. Okay, next question. Let's see. Is a reserve study account separate from our regular money market account? It depends on how you set it up. I mean, so it could be, or it may not be. Like for my association, we have reserve funds, but we have them invested in CDs that have, that they expire at different times, staggered times. But the funds are allocated as reserve funds. So I don't know. I think it's all in how you're allocating the funds, and assuming that you're not commingling them with the general checking account of the association. Okay, question number 17. And we have a total of 23 questions. So we're getting close to the end. To what extent is a reserve study useful to help make sure that insurance coverage for association-owned property is adequate? It's really unrelated. Basically, if you're looking at insurance coverage for your association, you want to look at what your CC&Rs say. In CC&Rs, there's typically an insurance provision that says what type of insurance you have to have for your community. Now, a related issue to this would be, the reserve study is it's a separate issue, and we have a cheat sheet on insurance too on our website at mulcahylawfirm.com that can help you better understand insurance issues for your association. How this could come into play would be like, let's use a tennis court example. The tennis court has fallen into major disrepair, and you're concerned that you need more insurance because somebody could fall, using the tennis court, or you've chained it shut, and so that could impact your insurance. Your insurance company may make you carry more insurance or an umbrella because you haven't maintained things in your community, or because maybe you've had a lot of claims due to lack of maintenance. Okay, question number 18. Could you do strategic planning in a workshop meeting called by the board and open to all homeowners? Absolutely. If you are the strategic plan, if you're not voting on it and you're just discussing it, a workshop meeting is, as long as it's properly noticed, if a majority of the board, which might be a quorum, is there of the board discussing it, then you certainly, could call it a workshop as long as no voting by the board is being done. And you want to make it open to the homeowners because under the open meeting law, anytime a quorum of the board is meeting to discuss association business, which strategic plan would be, you need to give notice to the membership and make it an open meeting. But if you don't want owners to contribute, just don't vote on anything, because the only time that owners are, able to contribute at a meeting by law is before the board takes formal action on something. Okay, what is the current Arizona condominium law regarding residential solar installations on HOA-owned roofs? Okay, so there's a number of laws. There's a couple of different laws that pertain to use of solar energy devices in an HOA or condo. We have a great cheat sheet that gives you the 411 on all of this, and we're sharing it with you right now. It's called Solar Panels and Creating a Green Community. The statute numbers and a description and the full language of the statutes is listed in that cheat sheet. Okay, question number 20. We have substantial damage to a brick wall due to a tree in the next property apartment community. They complied to remove it, but we are unsure if the roots were properly treated, so the damage continues at a slower rate. Who could I expect should pay for this repair? I have a lot of experience with tree roots and causing damage to, a wall. I'm hoping that you had, some sort of a construction expert come out and look at the wall and determine what exactly was causing, the damage, and why is the wall deteriorating, or why is the wall separating. Maybe you need to have the expert come back out and look at it again. Typically, once the tree is removed, the roots shouldn't be an issue anymore. I don't know how far, did they stump it, or did they actually, pull all the roots out? Have the expert look at it. If you can prove that through an expert, qualified expert, that their tree caused problems to our wall, you may have a claim against the neighboring apartment owner, and they may or may not pay it. If you send them a letter, you may have to go to justice court, depending on how much walls are expensive. So it might be Superior Court. But you're going to have to balance, how old is your community? When was this wall built? Can we decisively say that this tree caused all this damage? You're going to need to do like a 360 evaluation of this with your legal counsel to determine what's the best way to handle this. Okay, question 21. Should the HOA get an attorney involved to get a judgment lien, or can they do this themselves? And is there a time limit to seek the judgment lien? So really good question. Almost all Arizona condominiums and planned communities are considered nonprofit corporations, meaning that they have filed paperwork to limit their liability so that they are nonprofits. And why that is important is because there's case law that says that nonprofits cannot go to court to represent themselves, without legal counsel. So, short answer, should you get an attorney involved to get a judgment lien? I have seen some associations go to justice court or small claims court to get a judgment. And the homeowner doesn't raise the issue that they're supposed to have an attorney representing them. And I have seen some associations get the judgment and then record it. But to be perfectly proper legal advice, I would say that, the HOA really should get an attorney involved because they're set up as a nonprofit corporation, and there is case law that says that they should have legal counsel in any court proceedings. Okay, next question, 22. We have had occasional transients try to hide in our common property areas, and police have been called to remove them. However, it's becoming more popular. Police are harder to reach for this non-emergency issue. Do you have any suggestions? So I'm sorry to hear this. Obviously, this is a problem that is affecting our entire country. A couple of things. You may want to look at the areas where the transients are, hiding, and you may want to, put up some fencing or, other types of things that are going to deter from somebody wanting to, be there. We have had associations put up temporary fencing or permanent fencing. That would be, one example. You could post no trespassing signs. I think that would be a good idea as well. You could put lighting in these areas so that, motion detector lighting so that people aren't going to want to be staying there because it's going to have a bright light shining on it. I think those are some good suggestions. You may also want to reach out to, the police department versus, making a call, to their non-emergency line, maybe going down to the precinct and asking them if they have any suggestions, or reaching out to the neighborhood services department in the city that you live in. Maybe they have some suggestions that they may be able to help you with too. Okay, question number 23. It looks like we are down to our last 3 questions. Does an association have a right to know if there are any benefits the management company is receiving by maintaining controlled association funds at a specific bank? For example, vendor payments or rate benefits are provided by the bank to the management company. Okay, this is a really good question. This thought has crossed my mind too, especially with the recent, FDIC takeover of several banks, one in California, one in New York. It's concerning to me. And how that relates to this is, okay, so the management companies, we all know, try to push to have the HOAs that they manage all bank with the same bank. And I get it. There's a logistical advantage in that, the money is in one place. You have a relationship with that bank as the management company. Where I get into the worry zone is if you have more than the FDIC insured, limits in that bank, is that a problem? And I do think it's a problem. And what we're seeing and how this relates to this question is some management companies are pushing for associations to keep all their money, including their reserve accounts, with one bank. And that means that they have over $250,000 with one bank. And if that bank has a problem, and the FDIC needs to come in and bail out the bank, technically under the law, you're only entitled to $250,000, of insurance on the money that you have there. So if you have $3 million in there and the FDIC comes in and takes over the bank and the government isn't backing it dollar for dollar like they have been on the last few bailouts, you're really in a pickle as an association because you're out the money other than $250,000. So, are there benefits that the management company is receiving by, keeping all of the funds for the associations that they manage at a specific bank? I don't know the answer to that. That's a good question for the management company. And I would ask the CEO. I don't know if they're going to tell you or they don't have to, but it's a good question to ask. And, if I had to guess, there is a relationship there because of the large amount of money that is, at that bank because of the manager's relationship with the associations. Now, does that equate anything? I don't know. Maybe you contact I've never asked a management company that, but maybe you ask your management company CEO that and see what they say. And then keep in mind that $250,000 FDIC insurance, and don't let the management company pressure you to keep more than that in one bank. There are ways that you can, put that money into other banks with, CDs. There's lots of different ways you can do that. We have a blog on our website that talks about this. That would be a great resource if you're interested in finding more information on that. Best way to find that, go to mulcahylawfirm.com and type in FDIC in the blog search engine and it should pop right up. Okay, last two questions. How many cars can a homeowner have and park? The streets are city streets. So I don't know what your documents say on this. So do your CC&Rs, state that owners, can only park their vehicles in the garage? Do the CC&Rs state that owners can only park their vehicles in the garage in the driveway? So how many cars can you have? I don't know. It depends on what your CC&Rs say. This new law isn't going to go into effect for, you have to go back and look at the language on it, but I don't know if your association has CC&Rs that were recorded before December 31st, 2014 or not. So there's a lot of unknowns here. So how many cars can you have and park? Depends on a lot of different factors. I wish I could give you the answer on that. But look at your CC&Rs, look at when your CC&Rs are recorded, and then go from there. Okay, next question, number 25. We have less than 5,000 in our HOA account, and only 34,000 in the reserve account. Let's see. I requested copies of the insurance that is listed in the management contract. Insurance necessary for proper protection and preservation of the project, including liability and fidelity coverage for officers and directors. Manager will provide fidelity insurance for office personnel that handle HOA funds in the amount of $250,000. This was increased by $100,000 for 2023. Can a member request these, and are there any other insurance policies that would be helpful for owners that are in fear of losing their homes? Okay, so, good question. So you have very little money in your HOA accounts. You've got $5,000 in your checking account, $34,000 in your reserve account. You want to know what kind of insurance that it's listed in the management contract. I think you got to be asking for a couple different types of insurance. So what is the insurance that the association carries? Ask for a copy of all declaration sheets for all insurance that the association is currently has in place. If you want to know the different kinds of insurance that you may need for an association, check your CC&Rs, number one, and then look at our cheat sheet on insurance, which can be found at mulcahylawfirm.com. Just go to our cheat sheet, drop down on the first page, type in insurance, and it'll pop right up. After you look at your documents, read our cheat sheet, then look at the declaration sheet for the association's insurance. And look at how much insurance you have listed and see if it jives with, what your requirements are of your CC&Rs. You're asking right now for the management company's insurance. Well, that's okay, but that's not enough. I mean, of course, we want the management company to have insurance fidelity bond for if their employees stealing the association's money. They also need to have, liability insurance for the management company, but you need to be worried about, the association's insurance that's in the association's name too. Can you request this from the management company? They can, if it's part of the association's records, yes, it's a record that belongs to the association. If the management company has already given proof of insurance to the association and it's in our records, yes, you're entitled to see that. If the management company hasn't given it to the association, and you're making that request of the management company, they don't have to give you their insurance information. The association must give you a copy of the insurance policy for the association if you request it, and they have 10 business days to do that. Okay, next question is, what are the record keeping requirements for HOAs and management companies? So we have a great cheat sheet on this topic on our webpage, mulcahylawfirm.com. It's just called like records retention for associations. And we dial it in for you on that cheat sheet. We talk about how long you should keep minutes of the association's board meetings. I say forever. Keep documents of the association forever. How long do we have to keep information regarding a former owner? How long, do we have to keep owner lot files? Because things have mostly gone to the cloud for storage, a lot of associations aren't getting rid of a lot of documents. They're keeping their institutional history. And so check out our cheat sheet. We give you how long in years. Kind of a rule of thumb is going to be there's a 6-year statute of limitations for a breach of contract. So we want to keep most of the records for 6 years. Some of the records, longer, that are the history and institutional history of the association. Some of them we keep forever. So check out that cheat sheet on record keeping for an association on our website at mulcahylawfirm.com. I think it's called records retention. And that will give you some good tips on this. Okay, next question. What about a sweep account that supposedly keeps the money under the 250 limit? So I guess I'd have to hear more about the sweep account, but, so I'm guessing that my understanding of this is that, okay, you have a certain amount of money in your account with ABC Bank. And when it gets over 250,000, it gets transferred somewhere else. It's swept to another account. I don't know if it's going to the same bank. So it's $250,000 for all accounts in that one bank. So you could have a reserve account there. You could have a checking account there. But you shouldn't keep more than $250,000 in one bank. If that sweep account moves it to another bank, or to, a separate, like a CD or something with another institution, and that institution has FDIC insurance, then you should be fine. Take a look at our blog on this, because I think it really explains the, FDIC insurance and what associations can do to protect themselves. So thank you so much for being here today. We appreciate you caring about your communities and wanting to learn more, so that you can follow the law in your communities and make good decisions and plan for your future too. We have a couple educational opportunities coming up that are free for board members, managers, and homeowners. You always want to check out our webpage at mulcahylawfirm.com. We have our upcoming seminars listed on a tab right off of the home page, so you can find out information about all of our upcoming classes there. Our next virtual First Friday, which is the opportunity where you can join us on Zoom or Facebook Live, and we answer questions for free, one question per attendee, will be Friday, June 2nd at 9 a.m. And this will be our, June First Friday free call-in. And we answer those questions live. If you can't join us live, you can go back and watch the video and see your question get answered after the live presentation. You can find additional information on this on our website, and questions can be submitted starting right now through the morning of June 2nd at 8:45 a.m. We also have our June upcoming Neighborhood Services Virtual HOA Condo Academy. This class is going to be a really informative class. We're going to talk about everything you need to know about Arizona HOA and condo law in 60 minutes. So it's rapid fire. It's going to be quick. We're going to give you just everything at your fingertips that you need to know about for the law in Arizona regarding condos and planned communities. So we hope you'll join us for that. That should be an informative class that almost everybody in our industry can benefit from attending. Last things I just want to mention is that we sure would appreciate a Google review for our firm if you're so inclined to do that. We are always happy to get feedback from our clients and from anyone who's attending these classes about how we're doing. And that's a great way to do that. It gives us feedback first on the classes, and then it also helps attract other people to come to our classes. So if you're willing to do that, please Google Mulcahy Law Firm, and you'll see a spot when you Google our name, with the Google form to give us a Google review. And we would ask for you to do that if you're so inclined. Finally, I just want to say thank you again to the many different neighborhood services departments who partner with us to provide the virtual HOA Condo Academy. It's a pleasure to work with all of you. The cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe have been amazing partners to work with to provide these classes to you. They're free, and they care about your associations and your boards and your homeowners and want you to have the most up-to-date information so that all of you can effectively run your associations and follow the law. So thanks again to the different neighborhood services departments. It's our pleasure to work with you. And finally, we're at the end of our seminar. So I hope everybody has a great rest of the month. Happy Memorial Day to all of you. And I look forward to seeing you in June. Take care.